Hello everybody, welcome to EPG Pathshala. We'll be looking at the module on personal laws, uniform civil code and family law in India for the course Gender and Social Work. I'm Monica Sakrani. So in this particular module, we'll be actually looking at what are personal laws, what is uniform civil code, what is the debate on uniform civil code, and we'll look at what the family laws in India basically are. So we'll be doing a very brief overview of that because we really don't have the time to do it in great depth. But first we look at what is personal law. Now, as we all know, in India, our laws are determined by our religious identity when it comes to marriage, divorce, inheritance, and matters falling into the personal sphere. And this is something which has been there since time immemorial, and it was continued by the British when they came to power. Now, why is this whole issue of personal laws important is because in most other areas of law, our religious identity does not determine our rights, whereas in marriage and personal sphere, our religious identity determines our rights. Now, initially in India, it was more a caste and regional based identity which actually determined your rights, but when the British came, they didn't understand the difference in caste or region. So they basically, because for them their rights were determined in England, for example, whether you belong to the Church of England or whether you're a Catholic, that is what your rights differ on the basis of that, because Catholics, as per the Catholic Church, for a very long time did not have the right to divorce. So they assume that religion is the basis of identity and difference in rights in India also. And so that has basically continued over the years for different purposes. But so in India, when the laws or statute laws were made by the parliament also or this legislature, they continued to divide people on the basis of their religious identity. But having said that, for tribals and in many parts, customary law still applies. So customary law is not really religious law, it is mainly to do with your regional identity, the specifics of your community that actually determine your rights. So tribals still are determined by customary law, and even though we have statutory law for most communities apart from Muslim law, and Muslims for whom Sharia applies or Sharia law applies, for most other communities, if we look at the laws of marriage and divorce, it's mainly determined on the basis of the matrimonial laws in England. So the different laws which are there in India, if we look at it chronologically, then the Indian Christian Marriage Act 1872 and the Divorce Act of 2001. So it is the only law, Christian law is the only law where there are two laws, acts, one for marriage and the other for divorce. Now today we look at it as this is the first law, but historically the first law which was actually there was Parsi Marriage and Divorce Act which was revamped in 1936, so therefore that is now the year of the act. The other for Muslims are Personal Law Sharia Application Act of 1937 and the Dissolution of Muslim Marriage Act 1939 for Muslims. Now the difference between why there are two laws is Dissolution of Muslim Marriage Act gives rights to Muslim women to go to court for divorce. For all other types of divorces, as we are also hearing about the triple talaq case which is going on, that the Muslim personal law basically applies to non-court or non-judicial divorce, or what is known as customary divorce or religious divorce. Apart from that, you have in after independence, two laws which came about: the Special Marriage Act of 1954, which applies to those who don't want to have a religious ceremony and want to have a civil law of marriage, and the Hindu Marriage Act of 1955, which applies to Hindus. Now, apart from the Christian law, all the other marriage laws also give you rights to divorce. Now, what is Uniform Civil Code? Article 44 of the Constitution, which is there in the Directive Principles of State Policy, says the state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. Now, this is there in the Directive Principles, and the state has to endeavour to secure for the citizens that the uniform civil code applies. So this was very consciously kept in directive principles, and it was understood that in India there is a certain diverse culture, diversity is there, and religion, right to practice, propagate and profess your religion is a part of your fundamental right. So people have the right to also, minorities have the right to preserve their cultural heritage, and so cultural rights are also preserved under Article 29 of the Constitution of India, while right to practice religion is preserved under Article 25 of the Constitution. So there's been always this kind of friction which is there between the directive principle for Uniform Civil Code and the fundamental right for practicing your religion. So the first time this question came up of challenge to a personal law was in the state of Bombay versus Narsu Appamali's case, which is a Bombay High Court judgment. This came soon after the Constitution. There was a law which was brought in which prevented bigamous marriages, as many people would know. It was the Hindu Marriage Act which brought in monogamy as a norm amongst Hindus. Prior to that, bigamy was allowed. So, state of Bombay brought in a law much before that which prevented bigamous marriages amongst Hindus. So, it was challenged by Hindu men, saying that while Muslim men could marry more than once, why were Hindu men denied? So, it amounted to a violation of their right to equality. It amounted to discrimination, and the state could not discriminate between the two. So in this case, the court held that personal laws are not passed by the parliament. So the Muslim Sharia law is based on the religious law, which is the Sharia. So you can't say that the parliament passed a law, parliament made a law in which it allowed Muslim men to marry more than once and disallowed Hindu men to marry more than once. So there is no such discrimination made by the parliament itself. So law, they also said that fundamental rights would not apply to personal laws which are religious laws, and therefore because it did not amount to legislative or state discrimination. Now there is another case called the Ahmedabad Women's Action Group, which is an NGO, Ahmedabad based NGO, which filed a PIL in 1997 in which it listed down all the statutory laws which discriminated between men and women in terms of inheritance, in terms of rights, etc. And they listed all these out, and they said that these are all violative of fundamental right to equality, as they discriminate on the basis of sex. Now in this case the Supreme Court, and this was all statute law, so the Supreme Court said that we will not interfere because it is a matter of public policy. It is for the state to make a law. It is not for us to decide, tell the state what kind of laws to make. So we will not strike down these laws. Similarly, in Madhu Kishwar's case, tribal laws were challenged, and Madhu Kishwar had filed this PIL saying that tribals should be brought under the fold of Hindu law, and tribal laws should not apply to them. In that case also the courts refused to interfere by saying that tribal laws are very diverse, and so you cannot say that they discriminate against women per se, because many, as we all know, that all the matrilineal societies in India are governed by tribal laws. They are not governed by any of the statutory laws that have come in. But in two cases, one was Mohammad Ahmad Khan versus Shah Banu Begum, which is the famous Shah Banu case, and Sarla Mudgal versus Union of India, which is about bigamous marriages, conversions by Hindu men into Islam in order to marry again. In both these cases, the matters were before the Supreme Court. In Shah Banu's case, it was a question of maintenance to a divorced Muslim woman. The Supreme Court held that Parliament should formulate a uniform civil code. Even today, this debate continues with the challenge to triple talaq and the practice of halala, and we need to wait and watch about when we will get our uniform civil code. There are many articles written on uniform civil code. There are many kinds of debates which are there on uniform civil code. People like Nivedita Menon has written on it. There are Flavia Agnes has written on it. You will get a lot of material on the net. You're welcome to go and check all those out. There's also a very interesting paper by Rajeshwari Sundarajan which is there in your reference list, which you should read to see how nuanced the whole debate from a feminist point of view is on uniform civil code. Now we come to the next segment, which is family laws in India. As I told you all that it is on the basis of our religion that our family laws apply to us. So, my right to marriage, my rights on marriage, what kind of marriage should I have is all determined. Who will inherit my property when I die? So all these, what property will I inherit if any of my relatives die? So all these are determined on the basis of my religious identity. But we also have a uniform law of marriage, which is Special Marriage Act, where anyone who wants to opt out of religious laws can go and get married. But what happens if I don't want to have a Special Marriage Act? I don't have a marriage under Special Marriage Act. How, apart from these laws, is there any law for atheists? Is there any law for a person who marries under a particular law but does not, or has a different kind of customary situation? Now, in India, this is not allowed because the Hindu law is such that it is an omnibus law. It has a definition which is both inclusive as well as exclusive. So it includes all the sects of Hinduism, including Brahmo Samaj, Pratna Samaj or Arya Samaj. It includes Sikhs, Jains and Buddhists also. So there's no separate laws for Sikhs, Jains and Buddhists, and so it applies to everybody. The other is that it includes all those who don't call themselves Muslims, Christians, Parsis or Jews. Now we haven't spoken about Jewish law. Jewish law is also customary law. So it's not enacted by the parliament because there are very few Jews in India, but customary Jewish law applies to them. Now anyone who does not claim to be any of these four will automatically be assumed to be a Hindu under the Hindu law, and Hindu law will be administered to that person. Now before we move on to looking at what are the different types of marriage laws and other laws in India, we look at this whole concept of marriage. Now under all the laws in the country, which include Sharia law, there are three types of marriages, and they are valid marriage, void marriage and voidable marriage. Now what is a valid marriage? A valid marriage is one which fulfills all the conditions of law in a marriage. So we look at some of the conditions of law. Like for example, I gave you all the example of Hindu Marriage Act, which made monogamy the norm. So if I violate the rule of monogamy and have a second marriage, my law is not recognized by the law. So it is therefore not a valid marriage. It becomes so there are certain rules of marriage which may be what is known as voidable, means they are violated but they don't affect the validity of the marriage, but they give the right to the party to get out of the marriage if they want to. So for example, as we will be looking at in the next section, the child marriage. A child marriage, if I get married when as we all know, nobody can marry, a woman can't marry below the age of 18, a man can't marry below the age of 21. But what if there are, as often happens in this country, a person gets married when they are 15, 16 years old or 17 years old. Then that marriage is a voidable marriage and they have the right to opt out of the marriage. So a voidable marriage contravenes a condition which do not go to the root of illegality and which continue. Suppose I get married at 17 and I'm very happy. I have my child at 18, 19, I don't want to get out of the marriage. I want to continue with the marriage. So then I have the right to continue with the marriage. It becomes a valid marriage if I don't opt out of the marriage. There's a time limit generally given in voidable marriages, because if I get married at 17 and at 67 I decide that I don't want to it was a voidable marriage, I want to get out of the marriage, then I can't opt out of the marriage. Then my marriage will be treated as a valid marriage. A void marriage is a marriage which contravenes some of the fundamental conditions of legal requirement, and if they are violated, then that marriage will be a void marriage. So the example I gave earlier, that a Hindu marriage is supposed to be a monogamous marriage. If I get married to a second time, then that marriage would be a void marriage. It has no recognition in the eyes of law. And now what are the rights in a marriage? Rights in a marriage are basically similar in all personal laws. The most fundamental right is that you are each other's legal heirs and you inherit from each other. Your children are legitimate, so they have rights over all the property of both the parents. They have rights over both the parents. If a child is illegitimate, then the mother is the natural guardian or the legal guardian of the child. The child inherits from the mother and has limited rights of inheritance from the father. In certain cases he has the right to inherit, in certain cases he doesn't, or she doesn't have the right to inherit from the parent. The second is the right to divorce So you have all marriages in this country. Under Hindu law, marriage was supposed to be a sacrament. Under Christian law, marriage was supposed to be a sacrament. The only personal law, religious law, which treated marriage as a contract between two individuals was Muslim law. And so if either of the individuals wants to get out of the marriage, they can get out by way of divorce. Now divorce has become a norm or a fundamental right in all the marriages. And so it is one of the rights that arise out of marriage, the right to get out of the marriage if you don't want to remain in it. So now basically all marriages have turned into contracts and no longer are sacraments. The other right is also the right to maintenance to the wife, except Hindu law where the husband is also entitled to maintenance, the right to custody and guardianship of minor children, and another aspect over here which is important is because of the number of second marriages. Now one of the things that probably if you do a little bit of research you would come to know is that many of the marriages, second marriages or void marriages or bigamous marriages actually take place amongst Hindus, which are basically void marriages. So children in a void marriage are considered to be legitimate. If you don't get married, the child is illegitimate, but if you get married, the child will be still considered legitimate. So therefore, if a woman is in a relationship with a married man and is wondering whether she should go in for a marriage which has no validity in the eyes of law, then legally it would be more better for her to go through a second marriage even if the man is not divorced, because this will give her children certain rights because they will be considered legitimate under the law. Now we look at the Special Marriage Act. We are not looking at the conditions of marriage amongst all the laws because we do not have the time, but the Special Marriage Act gives a good template. And as I told you all at the beginning that most of the marriage laws in India are based on the English matrimonial law. So basically the conditions of marriage are more or less the same everywhere. Now one of the basic conditions of a marriage anywhere in the world would be that two people who are very closely related to each other by blood should not get married. So father and daughter, mother and son, grandparents and grandchildren, brothers and sisters cannot get married. So there's something called the degree of prohibited relationships. So under different laws you have different prohibited relationships. So basically you can't marry not only your brother or sister, you can't even marry your first cousin, you can't marry uncle and niece can't get married. So there are certain prohibited relationships which you cannot get married. There's a list of prohibited relationships in every act which is given. So you can go online, all the acts are available. You can, as I said, you can go to Indian Qanun and check out the laws. Even if you Google a law, you will get it. So they are all available. So you can check out the degrees of prohibited relationships. So they are basically more or less similar in all the laws. Then we actually look at what are the other conditions of a valid marriage in Special Marriage Act. The Special Marriage Act also says that a person who is under 18, if it is a woman, or under 21 if it is a man, cannot get married. They also prohibit marriage by people who are already married. And the other important aspect of Special Marriage Act is that it says that people who are, their consent should be free, and people who get married should actually want to get married. Your consent has to be free and not forced because of any fraud. So these are the basic conditions which actually make a Special Marriage Act valid. Now we look at child marriage. The first law with regards to child marriage was the Child Marriage Restraint Act of 1929. Now that basically made child marriage valid and only gave a provision for punishment for a child marriage. So if two children got married, then the family members who were responsible for the marriage could go to jail, but the marriage remained intact, it remained a valid marriage. In 2006, the Prohibition of Child Marriage Act was brought in, which made marriage between a girl below the age of 18 and a boy below the age of 21 voidable by the child within 2 years of obtaining the age of majority. So if I get married, if I'm a girl, then up to the age of 20, I can opt out of the marriage. If I'm a boy, up to the age of 23, I can opt out of the marriage. Now, it also made certain marriages void, where the child is kidnapped from the guardian's control, either through or married through deceitful means or force and taken to some other place and married, or where the child is, marriage is for the purpose of trafficking of the minor, or where the magistrate has issued an injunction prohibiting the marriage. So in this law, there are child marriage prohibition officers who are appointed, and they can prohibit they're meant to prevent a child marriage, so they can actually go to a magistrate and get an injunction saying that this marriage should not take place. And if the magistrate grants the injunction, then the marriage which takes place as a consequence of that would be a void marriage. In child marriages, women have the right to their property back, and they have the right to maintenance. The child will be, of course, considered legitimate if there is any child to it, a child born in a child marriage. Now we move on to divorce. Now in India, we have the system of fault grounds of divorce. Fault grounds means that in a marriage, two people, if they don't want to live together anymore, and they say that we don't want to get married, then they can get a divorce. And this law, this amendment has come in 1976. So this is known as a mutual consent divorce, that two people are saying that we don't want to make allegations against each other, we are just incompatible, we don't want to live with each other. So you file a petition for divorce before the family court or district court where there is no family court, and you say that I want a divorce, and we don't want, both of them make a joint application, they ask for a divorce. Now what happens when one person wants a divorce and the other person does not want a divorce? Now in that case, suppose I say I'm in love with somebody else, I want to get married to somebody else, I want a divorce. I cannot get a divorce in India, because the divorces are based on what is known as a fault grounds, that this is a sacramental relationship. In this relationship, who is at fault? Because if the relationship is not working out, then whose fault is it? So if I am in love with somebody else and the relationship is not working out, because it is my fault, because of me. If I have left my husband and gone away, then the relationship is not working out because of me. If I am beating up my wife, then the relationship is not working out because of me. So the victim of the innocent party in the marriage is the one who is entitled to divorce. And that is what fault grounds of marriage are. Who is at fault? The person who is at fault cannot take advantage of their own wrong. That is the principle on which this is premised. So there are various fault grounds which are listed out, and these form the crux of your marriage petition. So basic fault grounds are, of course there are many, under each laws there are certain which are common to all laws, certain which differ. Like for example, for Hindus, taking sannyas is one of the grounds for divorce. If one of your partners takes sannyas, renounces the world, then the other person can ask for divorce. Under the Dissolution of Muslim Marriages Act, a woman can get a divorce if her husband has remarried and is not behaving nicely with her anymore. So the common grounds of divorce are cruelty. Cruelty is held to be not normal wear and tear of marriage. Every marriage will have certain moments of fights, of anger, of expression of some kind of words which will hurting moments. So that would not be constituted as cruelty. Cruelty has been held to be both physical and mental. So a single act which is very excessive could be physical cruelty and could lead to divorce. Mental cruelty has been listed by the Supreme Court in various judgments. One of the important judgments which I would recommend you all read, which is there in your reference list, is Samar Ghosh versus Jaya Ghosh, which lists out what is cruelty. And so as I said, that mental cruelty has been held to be different from normal wear and tear of marriage. It has to be something more excessive, it has to be something more gross than maybe more continued, though single acts could amount to cruelty, as I've already said. The second ground for divorce is adultery. Again here, as I've already said, if I am in an adulterous relationship, I cannot file. If I am the innocent spouse, only then I can file. The adulterer has to be made a co-respondent in the case. That means has to be made a party to the proceeding. So I don't just file a case against my husband, also file it against the woman whom I'm alleging he's having an affair with. The third ground for divorce is desertion. Desertion means leaving the spouse and going away. Now, does that, it means more than just the physical act of leaving, it also means mental act. So there's something called constructive desertion. This means that if a wife is thrown out of the husband's house, can he say she has left me and gone away and therefore I want a divorce? No, he cannot. But can the wife say that he has thrown me out of the house and therefore I am asking for divorce on grounds of desertion? Yes, she can. So that is what constructive desertion means, that who actually has the intention to desert the spouse. And that person cannot take advantage of their own wrong. It is the other person who will file the divorce on fault grounds. Another ground for divorce is mental unsoundness of mind. So in this case, it should have been suppressed from the person, and it should not have been disclosed. If you already know that somebody is suffering from a mental illness and you get married to that person, then that would not amount to a ground for divorce. There's something which is coming up recently that is known as irretrievable breakdown of marriage. Now, most of the Western countries, including English law, on which the Indian law is based, have now moved away from fault grounds of divorce, and they're seeing them as more dated and anachronistic. So they have moved away now to this concept of irretrievable breakdown of marriage, where one of the parties says that I cannot live with this person, it's a marriage contract, I don't want to live with this person, I don't want to say that I'm wronged or whatever, I may not be wrong, but I just want a divorce. So this has become the norm in most of the Western world, and in India the Law Commission has also recommended that we should move to irretrievable breakdown of marriage as a ground for divorce. In certain cases, exercising its powers under Article 142 of the Constitution of India, the Supreme Court has granted divorce in cases where litigation has gone on for 15-20 years between the parties who have been living away, saying that the marriage has irretrievably broken down and there's no point in keeping the marriage pending. So they have granted divorce on this ground. Having said that, in India, before we move to a law on irretrievable breakdown of marriage, we need to have a law on matrimonial property. We do not have a law on matrimonial property. None of the marriage laws, including the Special Marriage Act, give the right to the wife or the husband over the other person's property on breakup of marriage. I told you all that one of the rights on divorce is that you inherit from each other, but if your marriage breaks up on divorce, your right to having a share of the property comes to an end. All that you have is a right to maintenance, which is in most cases very inadequate, sometimes not given, a lot of problems with it. So we need most of the Western countries which moved to irretrievable breakdown of marriage moved along with matrimonial property rights. So we need to have a law with regards to matrimonial property in this country. Now we move on to looking at succession. Now, there are two succession laws in this country. Hindu Succession Act 1956, which governs Hindus. Basically, it recognizes two types of property. One is what is known as self-acquired property, that I earn, my salary, my business, and the other is Hindu undivided family property. So, generally in Hindu families, the business is the inherited property. So my inherited house, my ancestral business, these are what is known as Hindu undivided family property. So there are two types of family properties. In 2006, women for the first time were given rights in the HUF property or the Hindu undivided family property. Prior to that, certain states, the first state was Andhra Pradesh in 1986. After that, Tamil Nadu in 1989, and several states followed this kind of line of giving women the right to HUF property. Women had the right to self-acquired property, but they did not have the right to HUF till 2006. Kerala had abolished the distinction between self-acquired property and HUF property in 1976 itself. So you have Hindu Marriage Act, Hindu Succession Act, and then you have the Indian Succession Act of 1925, which governs all other communities. So it has separate chapters for Parsis, separate chapters for Christians, separate chapters for Muslims, and separate chapters for those who are governed by the Special Marriage Act. Now basically all give They have only one type of property, which is individual property. All of these laws have two types of inheritance provisions. One is the right to write a will and give your property to whomever you want to give. All laws permit complete devolution of property by way of will. This is known as testamentary disposition of your property. Now, this is available in all laws, and your entire property can be given away except for Muslims, where under the Muslim law not more than 1/3 of your property can be given away by way of will. 2/3 of your property has to be given to those who are listed as your legal heirs. So this is the second type of disposition of property, which is known as non-testamentary disposition of property. So this is that if a person dies without writing a will, then who will inherit the property? So the law itself lists out who are these people. So they are basically close members of your family. Say for example, under Hindu law, the mother, the wife and the children, and any husband or wife or child of a child who has predeceased you, that means a dead child, will inherit the property in equal shares. So there are different laws which provide for different kinds of inheritance of properties, and of course you can, in India we know that the kind of gender bias that is there. Many of the women, our daughters, are disinherited from the property by writing a will, and this is in order to actually overcome that, the 2006 Amendment Act was brought in, because HUF property cannot be willed away. It has to go to whoever is the legal share, because it is the undivided family property. So it only remains within those who are your family members. So this was sought to be brought in in order to ensure that some of the property at least goes to the women. But this is something that we really need to look at along with matrimonial property rights, because women don't have any rights even after their marriage breaks up, and many times they are disinherited by their fathers. So they continue to remain in very, very difficult marriages, or they are abandoned wives. So when you are abandoned, what is your right? Your right is of maintenance. So we'll be looking at, under most of the personal laws there's a right to maintenance. Under most of the marriage and divorce laws, on divorce you get the right to maintenance. You can apply for maintenance and you can get it. But there's also a law, secular law, which applies to everyone, which is section 125 of the CRPC, or Code of Criminal Procedure, which governs all communities. Of course, it does not govern divorced Muslim women anymore, because the Muslim Women Protection of Rights on Divorce Act was brought in 1986 after the Shah Banu case, which gives, and Muslim divorced women are covered by that law and they get maintenance under that law, whereas a married woman who's a Muslim woman will get her rights under the 125 of the CRPC. So it provides not only maintenance for wives, it provides for all maintenance for all dependents, and the men, or a male adult male has to pay maintenance. What is required for him is not that he has the sufficient, he has to demonstrate that he has the means. The law will only assume that he has sufficient means if he is able-bodied. So any able-bodied man has to pay maintenance to those who are dependent on him. Who are those who are dependent on him? It includes a wife, including a divorced wife who is not remarried, parents, children who are minor, both legitimate and illegitimate. So the father has to pay maintenance for a minor illegitimate child also, and a major child who is physically or mentally handicapped. So he has to pay maintenance for all those. It excludes wives who have remarried, as I already said, or are living in adultery, or living separately from the husband on a mutual consent, or where the husband is willing to maintain her but she refuses to live with him without a just cause. Now, as I've already said, Muslim women are governed by the Muslim Women Protection of Rights Act. Now, under this law, the difference between 125 and this act is that under 125 you're generally paid a monthly maintenance. So your maintenance amount is fixed at, say, 5,000 rupees a month, and every month you will get your 5,000 rupees till the order is finally modified, or the husband says now she's remarried, now I don't have to pay her maintenance, or the child is now a major, so I don't have to pay the person a maintenance. So you don't pay maintenance after that. Whereas under the Muslim Women Protection of Rights Act, you pay maintenance as a lump sum. So this has to be paid as a lump sum to the wife, to the divorced wife. Now the law under 125 demands that a wife be a legal wife, but in the Supreme Court, recognizing the fact that many women are duped into marriages by married men, they do not know that the husband is already married, and sometimes they don't have proof of marriage. The Supreme Court has held that if a woman after her marriage discovers that the husband was already married to another woman, then she has to be paid maintenance by the husband. Now we move on to looking at guardianship and adoption. So Hindus are governed by the Hindu Adoption and Maintenance Act, where adoption is concerned. Hindus are the only community who have a separate law of adoption. Till the coming of the Juvenile Justice Act, no other community could adopt a child. And now under the JJ Act, everybody can adopt, and the Supreme Court has held that it is the secular law of adoption. But otherwise, under the Hindu Adoption and Maintenance Act, you can adopt only up to 2 children. And if one should be a girl and one should be a boy. If you already have a boy, you cannot adopt another boy, you have to adopt a girl. If you already have a girl, you cannot adopt another girl, you have to adopt a boy. But now under the JJ Act, you can adopt any number of children of whichever sexes. Suppose I want to adopt 2 girls, I can adopt 2 girls. But under the Hindu Marriage Act, Adoption and Maintenance Act, I have to adopt a girl and a boy. So this option, the JJ Act has brought in. The other law is the Hindu Minority and Guardianship Act. For the other communities, the Guardianship and Wards Act applies. Now, guardianship is both natural and legal. Parents are natural guardians and they are also the legal guardians, but the court, if it finds that the parent is unfit to be a guardian, can appoint another guardian. Guardianship remains till the person attains the age of majority. So in this module, we've looked at the overview of different personal laws in this country. We've looked at the concept of personal law, and we've looked at the Uniform Civil Code. All the laws, as I've already said, are available on the net. You can also look at the e-text and the list of references which is there. Thank you.